All right, if you're gearing up for the bar exams, you're in the right place. We're about to tackle a topic that's not just on the test, but is a huge part of day-to-day practice. How to handle matters in the federal court when the person on the other side is representing themselves. This is a critical skill, so let's get into it. Okay, here's our game plan. We'll kick things off with the fundamental challenge of self-represented litigants. Then we'll look at the tightrope the court has to walk, that balancing act. We'll talk about where the court draws the line on leniency, dive into the huge principle of open justice and its exceptions, and then wrap up with how the court handles precedent. And of course, we'll finish with the key takeaways you'll want to have locked in.
And this quote from Justice Wigney, it just nails it. This isn't a simple situation. It tests your skills, your patience, and really, your understanding of the court's core duties, not just to one party, but to the entire process.
So, let's start at the beginning. What is the fundamental problem here? When a person walks into court without a lawyer, what's the immediate issue the judge has to confront?
It all boils down to this. The court's #1 job is to ensure a fair trial. But here's the catch. That fairness has to apply to everyone in the room. And that creates this instant tension, right? How do you help the person who doesn't know the rules without being unfair to the party who does?
And that tension leads directly to this incredible balancing act. You've got a judge walking this razor-thin line between giving a helping hand and staying completely, totally impartial. So how on earth do they manage that?
Well, on the one hand, the court has a clear duty to provide reasonable assistance. It can't just sit back and watch someone crash and burn because they don't know procedure. But on the other hand, the court cannot, under any circumstances, look like it's taking sides. Its integrity is paramount.
So this is where the rubber meets the road. What does that actually look like? Well, the court can explain how things work, the process, the procedures, but what it can't do is step into the ring and become their advocate. It can't run the case for them because every move it makes in their favor could be a blow against their opponent. And here are some real-world examples of what that appropriate help looks like. A judge might say, "Do you need more time? Are you asking for an adjournment?" They might suggest, "You should probably put that into an affidavit." Or they might explain something crucial like, just saying that from the bar table isn't actually evidence. It's all about explaining the how, not the what. But, and this is a huge but, it is absolutely critical to understand that this leniency has very firm limits. Being self-represented is not a get-out-of-jail-free card to just ignore the federal court rules. You have to remember this line for your exams. It's from the full court in Manolakis v. Carter, and it is so powerful. It makes it crystal clear. You cannot use the court system as your own private royal commission, just firing off claims in every direction. Think of this as your exam checklist of what being unrepresented doesn't get you. It is not a license to ignore the rules. It absolutely doesn't mean you can claim costs for your own time. And this is the core idea. It can't put you in a better position than someone who hired a lawyer. And it definitely won't protect you from a nasty indemnity costs order if your conduct warrants it.
The full court in the Arsifin case really hammered this home. The rules are there for a reason. They exist to make sure justice is done properly and fairly for everyone involved. The court is not just going to toss them aside even for someone without a lawyer. Now, this idea of fairness for everybody connects directly to another massive, fundamental principle of our legal system, open justice. It's the bedrock, but it's not absolute. The court has very specific powers to make exceptions.
So what is open justice? Simply put, it's the idea that what happens in court happens in public. Anyone can walk in and watch. That transparency is what gives the public confidence that justice is being served. But sometimes, total openness can actually lead to injustice. So the court has the power to make what are called suppression or non-publication orders. Basically, it can say you can't publish this person's name or this piece of evidence has to stay under wraps. And for your exams, you have got to know where this power comes from. Burn this into your brain. It's Section 37AG of the Federal Court Act. I'll say it again, Section 37AG. That's your authority. But the court doesn't use this power lightly, not at all. The High Court has made it clear that the word to focus on is necessary. An order under Section 37AG is only made in truly exceptional circumstances where the interests of justice absolutely demand it. The bar is set incredibly high. Okay, last topic.
Let's talk about how the federal court manages its own internal business, specifically through the doctrine of precedent. You need to understand this judicial hierarchy.
This table lays it all out pretty clearly. A full court has to follow earlier full court decisions. A single judge is expected to follow decisions from other single judges, and also from state courts of appeal when dealing with uniform national laws. But you'll notice, in every single case, there's the same powerful exception.
And that exception is the key takeaway. It's the plainly wrong test. A court will follow a previous decision unless it's convinced that the earlier decision was, well, plainly wrong. It's a high bar, and it's what ensures our law is consistent and predictable, while still leaving room to correct obvious mistakes.
Whew! Okay, we have covered a lot of crucial ground. Let's quickly recap and lock in the absolute must-know points for your exams. Here it is, your 5-point checklist. Number 1, the court is constantly balancing assistance with impartiality. 2, leniency is not a free pass to ignore the rules. 3, open justice is the default, but you need to know the exception is under Section 37 AG. 4, that exception requires exceptional circumstances. And 5, precedent is king, unless it's plainly wrong.
And I'll leave you with this to think about. Learning these rules isn't just about passing a test. It's about preparing yourself for the real-world ethical tightrope you're going to walk every day, balancing your duty to your client against your paramount duty to the court and the fair administration of justice for everyone.